Families are beginning to take artificial intelligence firms to court. In a recent wave of wrongful death lawsuits, plaintiffs allege that generative chatbots acted as suicide coaches, encouraging the delusions of vulnerable teenagers with tragic results. AI models are migrating into clinical environments, taking over decision-making roles in hospitals, where the stakes are life or death. This bar chart compares the diagnostic accuracy of GPT-4 against the baseline performance of human emergency room doctors. In recent tests, the model demonstrates higher accuracy in identifying complex conditions. This precision aims to improve patient outcomes, but its unpredictable errors introduce a category of casualty that current medical and legal frameworks were not built to address. When a human doctor makes a mistake, centuries of medical malpractice law exist to trace the error, secure accountability, and provide a path to justice for the victims. When an algorithm misses a tumor on an imaging scan or provides lethal advice, that established chain of liability snaps. It raises a difficult legal question. Who is the defendant? Is it the software engineer, the hospital administration, or the algorithm itself? This creates what observers call an accountability vacuum, a situation where victims of AI-driven medical failures currently have no clear path to legal recourse. Modern medicine relies on the doctrine of informed consent. Doctors must be able to explain the logic behind a diagnosis or treatment plan so the patient can make an educated choice. Advanced machine learning introduces the black box problem. The system provides a diagnosis, but it cannot map out the internal steps it took to arrive at that specific conclusion. This creates friction at the point of care. Clinicians find themselves relaying diagnoses to their patients that they cannot independently verify or reverse engineer. Relying on these opaque systems removes the possibility of true informed consent, challenging the trust that the medical system is built on. In court, tech companies argue that their AI bots provide services or protected speech, rather than functioning as products that would be subject to strict liability laws. This classification makes it difficult for the Food and Drug Administration to regulate these systems as medical devices. This flowchart illustrates the FDA's solution: Predetermined Change Control Plans, or PCCPs. These plans set fixed rules for how an AI updates over time. But AI models drift. As they process new data, their behavior changes in ways a predetermined plan cannot account for. Health safety regulators are struggling to maintain oversight of an industry that is actively shielding itself from liability. Healthcare boardrooms are responding to this exposure by implementing reactive measures, like hard-coding crisis hotlines and mental health escalation prompts directly into the software. At the same time, AI is already saving lives. In fields like radiology, algorithms are reducing human error and catching false negatives that doctors might miss. Because the software is so accurate, hospitals are beginning to realize that refusing to use it could soon be considered a form of medical negligence. The standard of care is fracturing. Doctors are now caught between the systemic risk of using AI and the legal risk of working without it. We are delegating our physical and mental health to systems that currently operate outside of traditional legal oversight. The AI involved in your care could be a powerful medical tool or the cause of an unexplainable fatal error. Patients must now navigate clinical decisions in a system where traditional safety nets have been removed. If an AI makes a fatal mistake, the current legal landscape ensures that the responsibility is impossible to assign, leaving no one to blame.